back on the record with the Balle matter. Were you able to reach an agreement?
Yes.
Okay, all right. Let's go ahead and have you remain standing. Raise your right hands. We'll swear you in.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, to help you God?
I do.
Thank you.
Okay. All right. We're going to go through a few mandatory questions for approve up first. Ma'am, you filed a complaint for divorce in this action?
I did.
And you read that document before you filed it? And are the allegations contained therein true and correct to the best of your knowledge? And it's true that you and your husband have grown incompatible to the point where it's no longer possible for the two of you to live together as husband and wife. And at this present time, there is no chance of a reconciliation. Is that correct? And previously, the issues, all issues of custody and visitation were addressed by this court. Is that correct? And you're not currently pregnant, correct?
Correct.
And do you wish to have your maiden name restored to you now or in the future?
No, I'd like to keep my
Okay. All right. Then why don't, who wants to put on the record what the agreement is? Or do you have it in writing somewhere? Or?
She can just tell you.
Okay. All right. Go ahead.
Well, what we had decided to do is to do an alimony judgment at $4,000 a month for 5 years and $3,000 a month for 2 years.
2 years?
Yes.
Okay.
Child support.
Is that to start immediately? November, December?
Yeah, I guess. Whenever, yeah. And
Have you already,
January 1st? I don't know.
have you already paid? Because there was a temporary alimony award.
I've been paying that.
Have you paid for November yet?
Yeah, I just gave
Yes.
her the, yeah.
So
So the
December.
4,000 is going to start then December
Right.
or January?
December.
December,
Yeah, we might as
okay.
well start next
You
month.
wanna do
All right.
December?
Okay. That's alimony and
And then we add, whatever.
The child support that you've already put in
child
place.
support is previously ordered. Okay.
And regarding the business, we kind of, I don't know if we can do it this way, that we kind of incorporated it
Into the alimony. So
Okay.
there's not going to be a property.
We can, but give me a
Oh,
well,
okay, a number that was added.
give me a dollar figure, right?
It was
for
the
her half or the
$4,000
whole?
a month for the additional year.
How much?
It was,
The fifth year, I'm giving her the 4,000 is really, it's basically the value of the business part.
Okay,
But we're
okay,
doing
so
it as
4
alimony,
times.
not as property.
right, so it cannot be
So that way
dismissed
they
in a
can't-
bankruptcy.
Got it, got it. Okay, all right. So 4,000 times 12 is 48,000, correct?
Yeah.
All right. So here's what we're going to do then. We're going to, in that alimony award, when you prepare the order for me, the decree, it's going to state that there are $48,000 is awarded as lump sum non-modifiable alimony that will be paid at the rate of $4,000 per month commencing on December 2009 and terminating November 2010 with the last payment. Immediately thereafter, periodic alimony will commence at the rate of $4,000 per month for 4 years and then $3,000 per month for 2 years.
So that would be the first year would be that
The
part.
first year is, yeah, right, right.
Okay, so you're
Instead of
doing,
the fifth year, it's the
it's a
first year.
lump sum non-modifiable.
Lump sum non-modifiable,
Alimony.
right.
So basically, it's just like reduced to.
We got two different provisions for the alimony. One is we're going to call it lump sum non-modifiable, and then the rest of it will be regular alimony that
It is
terminates.
classified as alimony, so it can't
Yeah.
be dismissed in a bankruptcy or
Right,
That's why
Right.
we're doing it that
or
way.
Yeah.
So that was-
property.
right,
Okay.
right,
And so that's from 12 of '09 to November
right.
of '10, and then at that time we'll go to the $4,000.
Periodic alimony at the rate of $4,000 a month for 4 years, and then $3,000 a month for 2 years.
Yes, and we also incorporated rehabilitative alimony into that.
That was the extra $1,000 a month.
Yeah, and that's fine. You can call it just periodic and rehabilitative. You just call it that, and that's what it is. Okay?
He kind of added that in so that I could finish college.
Right.
And then the child support, whatever.
Yeah, whatever.
Right. And then, are there debts that need to be distributed? Okay.
Well, yeah, there's a lot, actually.
What about
We've kind of agreed to keep the credit card debts that we have in our own name
Okay.
to ourselves.
And then any like second mortgages and all that stuff will go in my name.
Any real property debts, is that what
Yeah.
it's called?
Okay. All real.
Yes, I'm just gonna file bankruptcy anyway. So.
Okay. And then, are there any other debts then?
There was just one outstanding debt, but we're kind of disagreeing
Which
on
one?
it, but he's telling me he's gonna declare bankruptcy anyway. I have a $1,300 outstanding bill for Nevada Power that was incurred when we were in the old house. And in the interim, before we got to court for any kind of, spousal support or anything like that, my revenue had decreased from what he was paying me, so obviously that got behind.
Okay.
So that's in a collections and it's sitting out there.
All right. Well, my typical ruling on that is if it's a joint liability.
We don't know, is it? Because I was living in the house with the kids.
This is after I
And
was
he had
out in
moved
2000.
out.
This is like in 2007.
And
Okay.
It was in my name and me and the kids were there living in the house.
All right.
And that was incurred from when I filed for a divorce.
Well,
April,
because
May
it's-
to August.
Because it's in both of your names, I mean, it's technically.
It's actually not. The power was just in her name.
Oh, the
only.
power was just in your name.
I had the power turned on in my name only.
All right.
That's what I'm saying.
Yeah. Then
But like I said, I went from going.
was this previous to any award of temporary spousal support and everything?
It was actually just before because I think we went to court in September. And
No, we went to court in August.
It was in like June that happened, right before.
All right. The debt technically would be a community debt. However, the court is not going to obligate either party to be. I'm not going to require him to pay contribution on that. If they come after you, they come after you. But yeah, that's going to be your debt. Well, the Nevada Power Bill is a community debt that each party is 50% equally liable for. If the defendant files bankruptcy and discharges that obligation, then he'll have no liability to you for his one half. Okay, that's the order.
Okay.
All right? So he owes half, but if he files bankruptcy, he doesn't owe you anything.
That's why I was like, please just take it because you're filing bankruptcy.
Well, it's not going to change things.
Right.
If it's
That's
in
still
your
back to her,
name,
right?
him filing bankruptcy isn't
Right.
going to help you.
Gotcha.
Okay? All right. So we've got that. That takes care of the debts. All right. And do we have cars and furniture and stuff?
Are you taking the Wells Fargo? The one that was a joint account?
Yeah, but the problem is, we don't understand how it works. If she has debt that's in her name and I take it, they don't care, right?
It's joint.
Yeah.
It doesn't have anything to do. They don't care if you say I take it, right? They're still going to go after her, regardless of what I do.
Potentially.
See, that's the problem.
Look,
I
the
can't
two of
just
you,
take it.
the two
It's
of you ought to
It was the only joint account that there was.
and listen to me. How much is it?
$6,000.
Okay. The two of you might want to talk to a bankruptcy attorney together before you file your decree of divorce. I'm going to grant you a divorce today, but if you're still legally married when one of you or both of you files bankruptcy, it covers everybody.
So they're-
You file it after the divorce, he can't discharge anything. I mean, just because I say it's his debt, it doesn't affect the relationship because the creditor's not here. The creditor's not a party. If the creditor has a right to go after you, they've got a right to go after you. I can't do anything about
And
it.
then there was there's an outstanding, I don't know what even, I don't have the information, so I'll ask you. The Allied Flooring Company, that was owed $7,000 for the repairs in the house that was foreclosed on.
Oh.
They were supposed to get paid by the insurance company, but the insurance company kept the check from the insurance,
Okay.
the mortgage
Yeah.
company kept it and never paid them. Do you have that debt, or has that been resolved?
They never, it's not in my name, it's in yours.
Okay, well, see, that's a problem.
Yeah, and
None of that was in my name because the house was, everything was in your name. That's, I mean, I would take it because
Right,
I'm just going to
no.
file anyway, so it doesn't matter. But
Right,
it's not
that's what
gonna
I'm
help you if I
saying,
do.
because, and technically, the insurance company was in both of our names, and they covered those repairs, but because the
But
mortgage that
look,
was.
But like he just said, if I file bankruptcy, it's still in your
Right.
name.
bottom line is, you can file together, or you can wait and see what happens, and if they come after you, then you might just have to file.
Okay.
Because nothing I do affects the rights of the creditors to go after the person or any individual that's liable. Okay, nothing I do can touch it. If you both go and talk to a bankruptcy lawyer, he can tell you how it works. You potentially could be protected from everything if he files while you're still married. Okay, but you need to go and talk to the bankruptcy attorney first.
Probably be better if we filed, if she's going to file, and I thought we'd do it together while we're married.
If you file jointly, if you file at the same time together, you pay one filing
Cheaper,
fee.
right,
Yeah,
exactly.
and then you don't have to
Otherwise
worry
it'd be
about
me and you
anything.
both.
It all goes, except for maybe some taxes.
Well,
if
yeah,
there's
I owe
some
the taxes, and
That
I'm taking
was
the tax
another-
debt also.
Yeah, he said he would take all the,
And husband will be solely responsible for any and all taxes.
I already have it worked out with the IRS. And then I don't know if we want to include the furniture and all that as part of the divorce because that's property.
Well, no, you got to put something in there. If you're each keeping what you've got in your possession, or if you're agreeing to,
She's got it all, so.
do we have to list that? I mean, it's
you don't
just-
have
I
to
have an
list
air
it.
mattress.
If you guys are in agreement, just put in there that the property and the personal property and household goods and furnishings will be divided equitably between the parties.
Okay.
All right. If you need to list it, list it. If not, okay.
Sorry.
So household goods and furnishings
Right? Is that okay?
distributed equitably between the parties.
And then the cars you're keeping.
Yeah, I already paid for it.
So you're making model?
Oh, I have the 2001 BMW 740IL. And then 2004 Suburban Z71. And then there's the jet ski. You tell me.
Property and we'll just deal with that ourselves, I guess.
I'm saying, but he's
No, on these
where it's
vehicles.
Oh, well, you,
going. On my side or yours?
On the vehicles, because you've got titles, you need to put something in the decree of divorce.
You wanted, didn't
yeah,
you?
the titles are all in his.
They're already
name,
in
right?
my
So he's
name.
keeping the
Motorcycle, the
BMW, the
BMW.
Chevy, the jet ski, what's the motorcycle?
Oh gosh, it's a 2004 Yamaha V-Star 650. V-Star 650, and the jet ski is oh god, I don't remember the name. It's a Kawasaki.
Do you want to put that in the paper or deal with that as?
Yeah, just put it in the paper.
I think it's an STX
Right, look,
15.
I don't-
I think it is.
To avoid having any problems with title issues, see if you can find the vehicle identification numbers and put
Oh
those.
yeah, I got all of it.
Those are the serial numbers in your decree. That way, you don't have a problem with it. And you have a vehicle that you're keeping.
Yes, it's a 2007 Chevy Avalanche.
Okay. And are there loans on any of these vehicles?
Yes, the 2007 Chevy, 2007 Avalanche, yes, there's a loan,
And you're going to pay that?
yes.
And you're going to be responsible for any encumbrances on any of the vehicles?
They're all paid off. Everything. Motorcycle, jet ski, and both cars are all paid
All right. Okay, anything else? Do either of you have IRAs, 401ks, pensions, retirements?
Oh, the insurance.
What insurance? Health insurance? Yeah, I'm going to continue to pay her health insurance for the next 4 years until she's done with school.
I have a pre-existing condition I can't get covered, so until I can get a job at the school district, I have no chance.
Okay, is that through your business?
Yeah, it's paid through. Yeah, it's actually paid through.
So
It's
you're
actually
gonna-
paid through my dad's business. Actually,
You're gonna keep her on as some
Yeah.
type of an employee or
right?
something.
Exactly. That's how it's listed right now. Yeah,
Okay.
and the kids are on there too.
All right.
And then the only other things, I have a life insurance policy, term life insurance policy,
Okay.
but there's no like value to it. It's just
Right.
terms.
Well, in that case, I would just ask that the children.
Children be named as the beneficiaries. Okay.
And as, however that works, is there custodial guardian, whatever, have that mentioned in there just for their,
We'll put in there that the children be designated as the beneficiaries on that. Okay. Is that everything?
I think.
All right. We did.
Well, there's also the attorney.
There's
There's the attorney fees.
right. There's the attorney fees.
Outstanding attorney fees is. the
Look, there was
only
a
other-
previously there was an award of $7,500 that was
But it got knocked down because she didn't pay for the car. You dropped off $1,000 or something on it for $6,500.
Okay.
900
But
off.
that I think that was
That's Neil Mullins, it was
right.
reduced to
That was
judgment.
now listen. That was in favor of Neil Mullins. So that's his. He has to collect that. I can't do anything with that today. There's the other issue that you have with your prior counsel. Are you doing anything about that other than what you filed in this court?
No, I mean, to me, the judgment shouldn't have been on me. We already went through that just because, I should have been awarded attorney's fees, which I have not gotten at all throughout this whole case.
Right, and like I said, the problem is, it's tough for me to award you. I can't award you attorney's fees today because you're not represented by an attorney. You've got this outstanding judgment for $12,000 that's
Does that work the same as like a credit card debt? You can't be transferred to me, and then it'll always be on her regardless of what I do.
it's one of those things where if you filed bankruptcy together, it would all go away. Otherwise, I'm not sure because they can always go after you for their fee.
Right, that's the problem.
If I make it an order that you pay it, and you bankrupt it, they can still go after you.
But at this point, that judgment is set aside. Is that what's going on?
Well, look, the problem is that there's some legal issues that are difficult for me to get a grasp on. They're entitled to a lien, and then they're entitled to try and collect on that lien.
How does what lien of what? A lien of what?
Well, it's just like a lien for services. It's just like if you work on somebody and they don't pay you, you can claim a lien against them. You can sue them.
Right.
But because they're attorneys and this is their business,
Yeah.
Right.
they can assert a lien against any judgment arising out of this case. Now, because it's all being classified as alimony, I'm not sure that there's a judgment there, but they can always go after you.
Which concerns me because a $12,000 debt like that, if I don't want to declare bankruptcy, will basically really ruin me. And it will make it very difficult, so I have to have some,
Right, but
so if I have to pay that, I have to pay it some way without taking it from the kids or the education part or the whatever. And like I said, I was never awarded any attorney fees throughout this. That's how I got this bill. And had they been paid a little bit or whatever, it wouldn't be where it is right now.
But if I'm not correct, if she got attorney fees, wouldn't that come off of the lump sum?
It could.
Isn't that how it would usually work?
It could. Not always.
So I guess I just deal with that legal issue as they pass it down when I get a job in 5 years and they garnish my wages.
I don't know, how long do those last? I mean, do they just
6
last
years.
forever? Oh,
6 years.
Okay. So don't get a job for 6 years. You get money for 7.
But other than that, I don't know what to tell you. So I'm not gonna adjudicate. I can't adjudicate any additional attorney's fees. I guess I can. You're definitely gonna file.
I pretty much have to. I'd like
All right. We'll take a stab at it. I mean, they still have recourse against you. Okay. Ultimately, they do. But the court is going to, the $12,000 that was previously reduced to judgment in favor of Dawn Throne and against you, I'm going to grant an award of attorney's fees against the defendant in the amount of $12,000 in favor of Dawn Throne, and this is as in for attorney's fees. It's not in the way of support. You need to make sure that the order says that it's attorney's fees, that it's not in the form of support or anything like that. That the $12,000 is reduced to judgment in favor of them. Okay.
And then so earlier
They're not going to have a judgment against you. They're going to, if they want to enforce their lien, they're going to have to come back into court. They'll have to give you notice, and they'll have to come in and try and enforce that. But
And as far as that goes, and I had that whole thing. Is there like an exemption order that has to be that is in this, or?
you mean exemption?
Like the child support and alimony part being exempt from.
Well,
Because the constable asked me for an exemption form signed by a judge, and I don't even know what that is.
I don't either.
Okay.
Well,
we both don't know.
the bottom line is, I don't know. You probably ought to consult with a bankruptcy attorney that it might.
I think that'd be the best, just to go in.
But that foregoes any future liens that she might put
Yeah.
on the, okay.
Yeah. Unless you go out and hire her again, she's done. All right, so based on the pleadings and papers in the file, the testimony heard here today, the court finds that all legal grounds have been met and good cause is shown. Therefore, we hereby grant an absolute and final decree of divorce, restoring you both to the status of single and unmarried persons, subject to the terms and conditions that must be included in a written decree of divorce that's going to be prepared by the plaintiff. Okay, it's your responsibility. You can do it on your own. I would suggest that you consult with an attorney or a paralegal and have it drafted. You could probably hire somebody to put that
I already have somebody in mind.
together for you. Okay? All right, and that's everything. Don't go and get remarried until you've got a decree that's filed. Okay?
Okay, so we just take, once this is drafted, we bring it to you.
Bring it to me and I'll sign it. Okay?
Do we sign it? Do I sign it?
Yeah, you both should sign it. If you go and you talk to the bankruptcy attorney and you want to sit on the decree for a while, that's okay. We've got everything on the record. You can hold off on submitting that if you decide that you're going to file jointly, because you've got to be married if you're going to file jointly. Okay? Otherwise, if you decide that you're just going to do it and you'll do it if you have to, then go ahead and just submit the order. And all right? Okay, good luck, folks. I know you are so happy to be right.
It didn't start off too well, though.